Hold on.
It's preparing.
No, it's
Oh, okay, terrific. All right, great. We are here in Senate Institutions. It's Tuesday, March 11th. We are back from our town meeting break. I think everyone went to many meetings. And we are continuing our conversation, our discussion on S71, an act related to consumer data privacy and online surveillance. Before we get to the testimony, I'd like to go around the room if you have time for that.
Yeah, I do.
Okay, and just, well, yeah, let's introduce ourselves.
Senator Russ Ingles, Essex District. It's good to see everyone.
Senator Joe Major, Windsor District.
And Rob Plunkett, Senator Bennington District. Senator Douglas, Orleans County District.
All right, and I'm Senator Wendy Harrison of Wyndham District. So let's start.
My name is Annie. I'm just here for the testimony. Megan Sullivan, Vermont Chamber of Commerce.
Joshua Diamond. I'm with the Guernsey Law Firm Special Counsel for the Vermont Chamber of Commerce.
Maggie Lindsay, representing the retail grocers and the State Privacy and Security Coalition.
On the Higher Vermont Ski Areas Association.
Emma Regan, the Crossing Group.
Drake Turner, representing EPIC, the Electronic Privacy Information Center.
Katrina Fitzgerald from the Electronic Privacy Information Center.
Thomas Weiss, citizen. I've been working on the data privacy issues in the legislature since 2018. Mostly trying to put the new bills into the context of the existing privacy statutes and unifying definitions. Some data elements are protected in some categories and not in others, and trying to make it more uniform so that the new portions work well with the older portions. And I would like to talk to you later about possibly testifying on that.
Okay, that sounds good. Thank you for your work.
Sarah Sevis, Attorney General's Office, Consumer Protection Unit.
I'm Zach Nominelli. I'm the Consumer Protection Advocate for VPIRT, the Vermont Public Interest Research Group.
Great. Well, thank you. And thank you all for being here. This is a really important topic. And so we have the Attorney General up first to testify.
Like Thomas Weiss, I've been working on this since 2018, and it's great to see you. One thing that I have experienced in working on this for a number of years is that a lot of the people who are focused on this represent a business or an industry, and it's really nice to have at least one person who cares about this so much. One of the reasons why the Attorney General's Office cares so much about data privacy is because of the intersection of data privacy and consumer work. AAG Sarah Sevis is here, who's been working on this for a number of years, and she's in our consumer unit, and that's for a reason. You think about when most of us were kids and how we bought things. We went to Ben Franklin's and we bought it. We went to whatever, the grocery store in town and we bought it. And now maybe most of the things we buy online. And online is free for most of what we do, but it's not free. Our data is used to purchase our experience, our time, whatever. And the intersection of data privacy and consumer issues in the marketplace is why the Attorney General is so involved, and why I personally have been so involved in this issue for a number of years. And this also relates critically to, in 2008, maybe 2009, the legislature passed the Data Security Notification Act that requires holders of data to notify the Attorney General's office if there is a security breach or a data breach. And what we have experienced is at least every day there is a data breach. There's usually more than that, 600, 800 notifications a year, depending on the year, is how much our office receives. When I've asked for a update from our self-described IT guy on what are the most popular web pages visited on our website, data privacy, the data breach notification page is always at the top or near the top. And that is because there are so many data breaches. For some, it's a matter of when, not a matter of if. And for that reason, we as policymakers need to be putting in place best practices that ensure data minimization is in place. So businesses aren't sort of not realizing, why would you collect someone's birthday for this? Why do you need their license to go to the dentist? Why do you, whatever the issue is. So codifying data minimization practices has been a priority for me, and you see this reflected in the bill. In addition, we have several cases that we have brought interfacing with data security, and that through the process of bringing those cases, we've learned a ton about some of the practices of the businesses and some of their maybe lax security practices, some of their bold security practices. It's kind of like the new frontier. We talked about AI, for example, and that has informed a lot of our knowledge and thinking around these issues and why they're really important to our office and why we care so much about this issue. The other thing I should note is, of course, our consumer assistance program. Now, I don't come in here a lot and talk about the consumer assistance program, but the consumer assistance program is a partnership between the Attorney General's office and the University of Vermont. It's located at the University of Vermont. It has existed for over 40 years. And a lot of people, when they say they contacted the Attorney General about a consumer issue, they've had, it's really the consumer assistance program that they've contacted. We call it CAP. CAP is an incredible resource, particularly for you if you have a constituent with a concern. Often CAP will have either the referral answer, like, oh, we don't do that, but here I can send you to the Department of so-and-so or Vermont Legal Aid or whatever it may be. But also they are experts in scams and identity theft. And we log 4,000 or 5,000 scam reports every year. Now, part of the challenge with data is that lax data security practices result in scams being easier. For example, most of the scams that are really effective are what's called imposter scams. It's someone pretending to be someone they're not, a sheriff, your grandma, or your nephew, whatever the case, a romantic partner, whatever the case may be. Well, if there's a lot of information about you, it's easier to convince you that they are that person, right? And so that dynamic and intersection of scams and data security is also a reason why we find this issue to be so compelling and feel compelled ourselves to be, sharing the knowledge that we have and trying to encourage the legislature to take action. What we do at CAP is we have a lot of data, and we also track, in addition to those scam reports, some of the scams with losses, and people steal other people's identities. It's very expensive. And so it's a concern that our concern comes from our knowledge. And I repeatedly have said, I think if the average Vermonter knew what I knew about data privacy, they would be activists and would be sitting in this room like the citizen who is here today as well. So we have also, I should note, up until the past few years, we've really been a leader in the data privacy space. I think it's because privacy is kind of part of the ethos of Vermont. We have a lot of freedom, a lot of privacy, like you do you. Everyone's allowed to do their thing, and we are private people. And so I think that it's a desire to reflect in our laws what the kind of ethos is here. We were the first in the nation to create a data broker registry. A data broker is a third-party person who literally is in the business of buying and selling data, but they're not connected to any person. They're a third party. We created a registry of people who buy and sell data, and other states followed Vermont in that work. And we are kind of, first on the scene there. But since that time, we've lagged behind, and other states like Connecticut have passed laws. One of the reasons why it has been challenging to pass laws, I think, is because one of the groundbreaking states in this area created a Biometric Information Privacy Act, a BIPA. Biometric information, your face, fingerprints, eye scan, DNA, stuff about you can't change. And it was controversial because bad actors were being held accountable at large sums of money, Facebook famously, millions of dollars. And so since the Illinois law passed, members of industry who collect data were thinking, I don't want to be sued. We all understand no one wants to be sued, right? I totally understand why they would want a different bill. And so they have worked hard to create a different bill. And I think what we have seen as all the states are kind of realizing that there needs to be a bill to do all the things that this bill does. They have over the years that work has been shaped by the industry who would be regulated by this bill. So that's kind of where we are at this moment in time. For me, I think it's critical that the bill be passed. And the reason why is because while my kind of interest in this work and my passion for making sure that we're doing our best by Vermonters in this work, that has continued, but things have changed, particularly when it comes to artificial intelligence and a new technology and a new era of being online, being in the world. I mean, I'm old enough to remember the .com days of the late 90s and how fresh and different and all the opportunities to create new things. I mean, it was a magical time. And I think AI is having a similar experience, but of course there's not all of it is good. And it's important for us to get ourselves straightened out when it comes to data privacy so that we'll be ready for new technology and kind of are right with ourselves when it comes to best practices and what our expectations are of industry, what consumers can expect, so that when the new technology is in place, we kind of have that foundation to build from. So that's where I'm coming on. When it comes to the bill, yes, there are changes that I would make if it were up to me. I think it's given that the date, I think it's important that this, it's a very good bill. I think it's important that the Senate get this bill over to the House. There isn't a lot of big sweeping changes I would make to this at all. This is not our first rodeo, of course. This bill looks pretty similar to a bill that was previously passed out of this body and the legislature itself. So there are not a lot of changes that we would make, but there are definitely some significant ones, particularly as it relates to our office. But as it is, support the bill and would encourage you to pass it out of committee and then pass it out of the Senate to the House.
Okay, thank you. Questions?
I have a couple. And I think you already know I'm on your side on this. I'm actually curious about the changes you'd want to make.
Well,
I'm talking about line. And
Getting
section.
into,
Yeah.
okay.
I like getting into the mix, and that's a lot of people don't.
Because you're a lawyer.
Yeah, it is. Yeah.
So for me, the area that was changed, so I know that this was listed as being an S71, S93 is another bill.
Yeah.
And I can't remember which is which, but one of them has things a little different. So let me put my glasses on so I'm not pretending that I can see without them.
Sorry to put you on.
No worries. And towards the end of things is when the Attorney General's job, if someone else knows where it is, tell me. I know it's towards.
So in 71, it's page 61.
Okay.
The public education part.
Yeah. So do you want me to talk about S71 or S93?
S71,
Okay.
or actually both if you can.
Okay. so
Actually, your powers start at 56 of this 71.
this is the study, right? Okay, so 56. So I can get there. Yeah, there we go. So S71, this is with regards to the cure period. So S71 on the bottom of page 56, you've got 2424 C1. So if the AG determines a violation has happened, may be cured, I fixed. The AG may, prior to initiating any action for the violation, issue a notice of violation and give the person 60 days to fix it. So normally, let me tell you how our office does things. Normally, we will learn that there may be a consumer protection violation, and we will, by statute, this is all very boring, we will issue what's called a civil investigative demand, CID. And it is basically asking questions to get more information to figure out, like, is this thing really happening? Are we right about this? Like, what's going on here? And we kind of get to the bottom. We have investigators who do that work and they will process the data. And sometimes we interview people, but a lot of it is just on paper. And then we might say, okay, we were, there's nothing here. We did our investigation and we're done. And then sometimes we're like, wow, yes, there has been a violation here. And then we go to the person and we're like, we think there's a violation. Here's why. And we would like to settle with you. And then we might go back and forth. And then we might settle, or they might say, no way, we're not settling, we disagree, and we might sue them in court. That's the way things normally happen. So imagine in this case, if you had a 60-day cure period, and I'm going to use a dramatic example, and this might not be it, but this is what could happen. Imagine I find out someone calls the consumer assistance program. I shouldn't make up a name of a website because it probably is a website, but badwebsite.com has posted my social security number in 400-point font right on the homepage. And there it is. Imagine I have to wait 60 days to like do something about that. That's obviously very dramatic, but truthfully, that's kind of so I get the thought behind this, but in my mind, and maybe this is me, I trust myself and the office because we're good actors. It's like, well, yeah, I mean, if there's a way to help, people get things fixed, that's great. But does that mean that that person shouldn't be held accountable? The cure period, I like this one, May. It provides a discretion of, okay, this was obviously, a mistake, the harm is low, like, let's just have it fixed and we're going to move on. Right now, that's pretty much what we have. We have a lot of discretion in the Consumer Protection Act. It's worked very well for going on 60 years. So I like that version. That's the thing that I like. The other thing, and it's in the same section.
I'm sorry. I just wanted, when you say settle, are you talking a monetary judgment or?
It sort of depends on the case.
Okay.
Sometimes under the Consumer Protection Act, the monetary settlement that we could pursue in court is up to $10,000 per violation. The other thing I should point out is this is a temporary situation and under the statute. So the May is, I think, we would eventually get there. This is just for easing people into it. So it's not the end of the world. But to me, I just think I don't understand the reason why. I think that it's better not to have that. We already have discretion. Did you have more questions?
Not yet.
Okay. All right. I'm going to move on to the next thing that I'm just not crazy about. So on page 57, right under the previous section that I had mentioned, 2, the Attorney General may, in determining whether to grant a controller, etc., the opportunity to cure, consider these things. Well, this is fine, but generally, I don't know that it's necessary. And I don't know if it says shall in S93. Let me look at that and make sure. Because we have a lot of, there we go. Yeah, oh no, that's the report. So here we go. Oh, this is a May too. I mean, again, it's just, to me, it's just not necessary and you can leave it in there, but that was the other thing that I have always thought. We already have the discretion, so I'm not sure that this adds anything. And in fact, in some ways, it could be read as limiting potentially, and it's a may, not a shall, so probably not, but we're just not accustomed to having that kind of thing either, so it caught my attention.
So you would rather will?
No, I'd rather just have it struck.
Okay.
I mean, well, I should say maybe I don't understand why it's in here and that's why I would strike it. But if there's a good reason for it to be here, leave it. But it just doesn't seem necessary to me. And I think this bill, unfortunately, has notoriously been too long and it's made it difficult, I think, to get it through the legislature. And so looking for opportunities to streamline that seemed like a logical place.
With that, is it fair to say you consider all those factors and amongst many others anyway?
Yeah, exactly. That's exactly it. Yeah. The other issue that's been controversial is the private right of action. I thought I would just take a moment since Senator Plunkett likes to get into the weeds to describe what a private right of action is. This is a consumer remedy. So picture yourself, you've been hit, you're driving somewhere, minding your own business, and someone crashes into and totaled your car. Should you be able to sue that person to get the cost of your car? I think you should. And in general, I think consumer remedies are a good thing because that reflects how our justice system kind of works, right? And not justice system, our judicial system works. Like when someone is harmed, they can bring under a private right of action, for their actual damages, right? Remember I mentioned that Illinois law? It didn't have actual damages like the cost of your car. It's statutory damages. And so it is a different animal. And I think sometimes the people who don't like that law conflate it. It's not that law. And so people are worried who collect data, and I get it. They're worried they're going to be sued because of a private right of action. But the private right of action is actual damages. So if anyone testifies and says, we don't like the private right of action, I would encourage you to say, can you walk me through a specific example about what you're afraid is going to happen? Because how are they going to quantify actual damages? And what I previously heard is people are worried about like plaintiffs firms who do class actions pursuing an action that would be a long process for, you know, the data holder, and they were not interested in that. But the truth is, when it comes to actual damages, one, I think a consumer should be able to pursue that. Two, no one's been able to articulate to me, like, what exactly are you worried about? So people say like, oh, that would be bad. And I'm like, again, 5 years going, I keep asking how. And so far, no one has really adequately even begun to describe like an example of why they're worried. So I would just encourage you to get to the bottom of that, because I think that it's an important part of the story. The Attorney General cannot bring cases on behalf of individuals. We only represent the state. So right now, under the Consumer Protection Act, and as has been the case for 6 years, and I think in every single state, there's a private right of action for actual damages. It's not the 10,000 that the Attorney General has, it's actual damages suffered. So I think that a private right of action is in keeping with I don't know why data privacy is this unique and special area that will be carved out of all of the rest of consumer law, other than people are afraid because Illinois had a not actual damages. They had a different actual amount in the statute. So that's where we are now. Lucky me, I'm the Attorney General. I would have power to enforce anyways, but on behalf of consumers, I think Vermonters would want that power. So I always advocate for it.
Senator Ingalls.
So what would you say to all the people who are against private right to action, that it increases the chance of lawsuits, especially from out of state people, to jump in and class action suit or what have you?
So again, how? What's the actual damage?
Because history will tell you that that's how it's been when there's
In Illinois.
private right of action everywhere.
No. In Illinois, there have been a lot of cases. Of course, there's been a lot of harm in violation of the law too.
Not just in this, but in private right to action. When there's a private right to action, it just opens up the lawsuits.
It doesn't. We've had private right of action under the Consumer Protection Act for 60 years. This is the first you're hearing about it because that doesn't happen here. And it's actual damages. It's linked to actual damages. And that's why I keep pointing that out. It's really important to know the difference. So if that were true, wouldn't we have been seeing it for 60 years? And this is the first anyone's ever hearing because it hasn't happened. So that's why I'm not worried about it. Also, I think Vermonters who are harmed want to be able to have an avenue for a consumer remedy for themselves. And the Attorney General can't represent individuals.
But you can represent them on behalf of Vermont. And you're
Yeah, and I do all the time.
Okay,
So, but it's kind of, industry's making it sound like there's going to be a ton of violations, and that's why they're worried. So do you want to have more staff on my office so that we can make sure that we're bringing those actions if there's going to be so many that everyone is so concerned? Should the taxpayers be paying for more lawyers to bring those lawsuits?
right.
So that individuals can't, because we don't want individuals to be able to bring their own actions like they can for the rest of consumer law. I mean, this is like a policy choice you're all making. I obviously know where I stand, but I do think it's really critical to ground your decision in what's actually happening and not on what people are afraid of happening in 2008 in Illinois under a totally different remedy that is not a part of this bill.
Do we as a state keep track of lawsuits and what type of lawsuits? And
People won't report to our office that. We have done some research that Sarah did, and it was very minimal. I don't know if you remember, Sarah.
Under 10.
It was under 10 a year.
under 10
Or no,
private,
under 10 total.
Total.
for,
forever.
For what? For
For
consumer?
Consumer Protection Act, private right of action being brought.
under any area, not data privacy, but any.
Yeah, right, any Consumer Protection Acts.
So for per year, it was
No, hold on, ever.
over 60 years.
I'm sure that there's
Okay, but
more, but that's all that we could find.
wow. Yes.
So this actually jumps out. I was gonna ask, why is the CTA not enough? And then it's gonna ask, why is it too much? I think we answered the, why is it not enough? Because there are no lawsuits. The bills, both of them, restrict private enforcement to the bill itself and take the Consumer Protection Act out.
Yeah.
Why would that be a good thing? Why don't we just point to the Consumer Protection Act?
Yeah, this is part of my concern is right now there is that private right of action and this would limit that. And that's exactly right. So one of the things, so the Consumer Protection Act, which is a powerful act, and let me remind you, when you protect consumers, you protect the marketplace. Because the marketplace isn't going to work if consumers are nervous about investing, about buying things, about interfacing with the marketplace. And of course, the marketplace now is largely online. So we found that with robocalls. Remember I used to buy stuff. Someone would call you and you'd be like, sure, I'll take those Omaha steaks. No,
I was actually the caller.
you were the caller.
A long time ago.
Yeah, right? That was a normal thing. And then robocalls killed that marketplace and no one even answers their phone anymore. Imagine if that happened to the internet. The internet is fueled by our data and us buying and things online. So trying not to get on my, I don't want to spin out in my fears of the destabilization that AI is going to have on the online marketplace. But the Consumer Protection Act has 3 parts. So if you can show there was a misrepresentation in the marketplace, the consumer relied on that in a reasonable fashion. So you didn't say something crazy like this car can fly, right? You know that's not true. That's crazy. But if you said something that was reasonable, it was relied upon by the consumer, and that misrepresentation was material to the ultimate choice the consumer made, that is how you are create a violation of the Consumer Protection Act under deception. Then there's another prong that's unfairness, and that's unscrupulous, against public policy, and that kind of thing in the marketplace. So that is that. Now imagine that's what you're having to prove in court. A lot easier than you were supposed to notify by X date. You were supposed to, whatever the thing is, you were supposed to delete this data by X date and you didn't. Well, that's a much quicker way. Also makes it a lot more clear to businesses. Businesses like that predictability, the stability of knowing we just got to follow the rules. The rules are right here. They're well laid out. We understand them and we're going to follow them. It works when there's an issue like this, which we know can be a problem. We're articulating a clear rule for the businesses they can follow. And then when the statute is violated, consumers have an easy way of getting the remedy and not having to go through a long process of establishing under the regular Consumer Protection Act. So that is one philosophy. And you actually will see that throughout. You can pull Title IX off the bookshelf. I love how I'm gesturing to a bookshelf.
Yeah.
You can pull Title IX off of a bookshelf and look, and you can see there's all these different consumer areas that you might not even think would be there, treatments in furniture products, or going out of business sales, propane. I think the Vermont Origins rule is under there. There's all different kinds of consumer issues that relate, and there's more meat on the bones in some of these areas that require that kind of clarity for the businesses and also for consumers.
Okay.
I can keep going, but
Same.
Well, maybe we'll have that. But thank you very much for your time. Thank you for your time.
It is my pleasure to be here. Happy to answer any questions or get you any other data we have that we can provide it. Just let us know what you need.
Thank you.
Okay, thank you.
thank you very much.
Next witness is Katrina. I hope I'm saying your name correctly.
Katrina.
Katrina, I'm sorry. That extra I in there, Fitzgerald. And so if you can please introduce yourself.
I'm Katrina Fitzgerald. I'm Deputy Director of the Electronic Privacy Information Center at EPIC. Thank you, Chair Harris, and Vice Chair Plunkett, members of the committee for having me in today to testify in support of S71. EPIC is a nonprofit independent organization founded 30 years ago to secure the fundamental right to privacy in the digital age. I celebrated 10 years at EPIC last week. Before that, I worked in the Massachusetts legislature for 6 years. State policy is close to my heart, and I'm very fortunate to get to work with lawmakers in Vermont and across the country to advance pro-consumer, pro-privacy laws. I want to commend the sponsors of this bill for the incredible work they did, building on effort that was put in last year by this legislature when you passed a very strong privacy bill. It's obviously very disappointing when that was not signed into law. But the Senate 71 builds on that book. As you all know, our data is used in ways we don't expect constantly, like apps, data brokers, advertisers are constantly tracking what we read, the websites we visit, who our friends are, what those friends are reading and doing. And they use this data in ways that are so beyond our expectations. And in a time when policymakers are rightly concerned about affordability and kitchen table issues, this has a huge impact on your constituents' wallets. Everything from the price of insurance, the price of groceries. Texas Attorney General sued Allstate Insurance last month for using apps like Life 360 to track people's locations and raise their auto insurance rates based on that information. The FTC just released findings last month that retailers are using everything from people's location to their browsing history, even their mouse movements on a web page, to target individual consumers with different prices for the same goods and services. And this entire online advertising ecosystem is not great for small businesses either. They're left paying big tech, big money to advertise with little accountability about where their ads are being shown or how effective they are. So it's bad news for small businesses, big tech keeps getting richer, and all of our privacy suffers. It doesn't have to be this way. Good privacy laws can protect privacy while allowing businesses to reach their consumers. I'm not going to say much more than that on why Vermont should pass a privacy law. I don't think there's anyone other than the folks profiting off all this data that looks at the current state of things and says, let's continue down this path. This is fine. So instead, I thought the best use of my time might be to talk to you a little bit about what's going on in other states on state privacy, talk about how S71 builds on that work, but goes a little further to protect Vermonters, and finally, the ways that Vermont businesses will be able to advertise into the bill.
Great.
That sounds good?
Yeah, sounds perfect.
Great. So 19 states have so-called comprehensive privacy laws so far. Unfortunately, most of these laws are heavily influenced by big tech, and so they don't go far enough to protect consumers. EPIC and US Bird recently released a report scoring state privacy laws, and nearly half failed, and none received an A. I know there's another bill that's been introduced that's in another committee, Senate 93, that's modeled largely off Connecticut's law, and it's law received a D on our scorecard. And in fact, the original sponsor of the Connecticut Data Privacy Act, Senator James Maroney, has introduced a bill this session to strengthen that law. So they have looked at.
And I'm sorry, I mean that. So I guess what was the grading mechanism that was used? Because I think that's important to know if you get an A, what the playing field was.
Absolutely. We published a scorecard, how we assign points. We, came up with a metric that as a privacy organization, as a consumer organization, what would an ideal privacy bill look like? And then scored on that matrix. I'd say the biggest weakness that we saw in Connecticut and other states' bills is that they put the onus of protecting privacy on the consumer and put very few rules on the businesses that are collecting and using and abusing data. So that is the main thing we were trying to push forward. And that's what S71 does. It builds on Connecticut's law, actually uses Connecticut's law as its base text, and then puts strengthening amendments on top of it. The primary change is this rule called data minimization, which we touched on. And the rule in Senate 71 better aligns businesses' data practices with what consumers expect. It sets a baseline requirement that entities can only collect and use personal data that's reasonably necessary for the product or service I'm asking for as a consumer. Right. So Meta can collect data about what I do on Facebook and Instagram. They can target me with ads based on that data. I expect them to do that. But they can't put trackers on every website I visit and monetize my every click online. Right? I don't expect when I go to WebMD's website and I search for symptoms that what I'm reading is getting sent back to Meta automatically in the background, but that's exactly what's happening right now. So the key with the good data analyzation rule is to ensure it's tied to that specific product or service I'm asking for as a consumer, not whatever purpose the collecting entity decides they want to collect it for and list in their privacy policy. That's what the Connecticut law says is business has to limit collection to what's disclosed to the consumer. You know, I don't read all those privacy policies, never privacy expert, you know, you would do nothing else with your time. So that is the big change between Senate 93 and the Connecticut law and Senate 71. And like I said, Connecticut also has a bill introduced from the main sponsor, the initial sponsor of that law, strengthening that bill, that law. So what this would mean for businesses, you know, last session, I know the earlier iteration of this bill was criticized by business and technology groups for kind of a lack of clarity around advertising rules. So sponsors of S71 put in a lot of work, talked to a lot of stakeholders to really add that clarity. It defines a few different forms of advertising and sets out the rules for each. So one form is contextual advertising. This is kind of how advertising has always been. It's, or at least before this craziness now. You know, contextual advertising is basing an advertisement on the content of the website you're looking at, the magazine you're reading, the radio show you're listening to. So if the Red Sox place an ad on the ESPN site because they know sports fans generally visit the ESPN site, that's contextual advertising. It doesn't require any personal data at all. There's no restrictions on contextual advertising in the bill. First party advertising is when a company uses data that they collect from a consumer to advertise in their own location, on their own website, via direct communication, via email or catalogs or text messaging using data they've collected from the consumer. So if I buy an ad at Orbis, they can send me an email advertising the matching gloves. As long as it's not using sensitive data, companies are free to do first party advertising under the bill. No other restrictions, as long as they've initially collected that data because it was reasonably necessary to provide me a product or service, they can use that data to advertise. Then there's targeted advertising. Targeted advertising requires tracking consumers and building profiles about them to target them with ads based on that data. There's a couple of different forms. Most invasive form is behavioral advertising, and that requires tracking across the web. That's the WebMD example I mentioned earlier. Every website I go to, tracking my information, sending it back to a dozen, it's not just Meta, a dozen plus advertisers. I use a blocker in my browser, and a lot of websites I go to will be like, 47 trackers have been blocked from profiling you. It's insane. So nearly every website you visit, sending your browsing history back to this advertisers. So we view this as the most harmful form of advertising because people just don't expect it. They've contracted with those companies, but these companies know everything they're reading and doing online. So S71 makes that type of browsing data sensitive data, so it can't be used for advertising. Another form of targeted advertising is retargeting. This is what a lot of people think of as targeted advertising. I go to the Nike website, I look at a pair of Nikes, now everywhere I go online, I see those Nikes and follows me everywhere. That's retargeting. Retargeting is allowed under the bill, but consumers can opt out of it if they don't want to see those kinds of ads, either on a site-by-site basis or through a universal one-click mechanism saying, I don't want that kind of trend. So the long and short of it is this bill gives businesses plenty of ways to advertise and even reach new customers. Will some large ad tech firms have to change their business practices to be more privacy protective? Yes. Will Meta have to rely on data I expect them to have rather than tracking my every click online? Yes. But Vermont businesses can still advertise. They can do so via their traditional channels of using their customer lists to reach them directly. They can do that by working with ad tech companies. But those ad tech companies are going to have to do things in a more privacy protective way. And Vermont wouldn't be alone in this. And Maryland passed a bill with good data minimization language last session that comes into effect this October. Like I said, Connecticut's looking to strengthen. Massachusetts has a very similar bill to S71 introduced this session. So Vermont wouldn't be alone. There's a lot more to this bill, obviously, but, including some really important protections for kids and teens online, a ban on the sale of sensitive data, which is so important, strong enforcement measures and more. But that data minimization piece is so important that, I thought it was worth focusing on that. And I hope it was helpful. So I ask you to pass, S-71 as committee and vote yes for it on the second floor. And thank you for the opportunity to testify.
Thank you. Go ahead.
Do you know the bill number for the Massachusetts bill that they're introduced?
Well, they just got new bill numbers yesterday because they were just assigned to committee. So I can get back to you with that. It has a docket number, but it has a bill number as of yesterday. I don't know off the top of my head.
So, and if you can provide us written testimony, that would be great.
Yes, I actually did send some in last night. So.
Oh, good, thank you. And then just a quick question. You were talking about the sale of, personal data or, bio data, basically. Medical data, I think it's what it's. So I'm presuming there's no sharing of data without compensation somewhere.
How do
Do you
you?
mean like companies just sharing data or making it available for free and truly free? So, they don't get something later on, or they're not affiliated with who they're sharing it with. Is
Right.
that an accurate way to think about it?
Yeah. So a lot of, there are, the Attorney General mentioned there's data brokers that sell data. So they're, getting paid to sell
Right.
lists. Then there's also, in ad tech kind of systems, there's the Googles of the world, Facebooks of the world, they don't sell their data or make it available free. They sell access to their data. So, let us target ads for you. You pay us X amount and we'll look at all of our data and decide who to show your ads to.
Yeah, so I would put that in the same category.
Yeah.
Yeah, I think when the internet was new, there was more sharing. And some of it actually not for profit, not to get a profit. It was scientists sharing with each other. I mean, that was a long time ago. That was the beginning of the internet was the scientists sharing.
But I will say when there's a data breach, sometimes that information is posted.
Right.
Online, and they'll come, I don't know.
But not
Anyone-
intentionally, but yeah.
Right, or
No,
I don't
maybe
know.
intentionally.
Yeah, I mean, just for, I guess, recognition or something if they're hacking, but, National Public Data was a group that was breached last year, 2.9 billion records, including social security numbers, and that was just posted online. Right? It's terrible.
Right, so it's weaponized too.
Right.
Yes, yes. Well, thank you very much. I look forward to looking at your testimony too, your written testimony. Anybody else have a question? No, thank you for your work.
Thank you all.
Okay, next is Erica DiLorenzo. Don't see her here. Okay, then let's go to Josh Diamond. And Megan Sullivan, however you want to present to us. You want to do it
Thank you.
together?
Chair Harrison, maybe we both can come up with that.
That's perfectly fine.
There's another chair back.
Oh my gosh.
That's a rare commodity. It's a jackpot.
Full time.
Okay, so you
good
can introduce yourselves.
Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce.
Chair Harrison, members of the committee, Joshua Diamond. I'm a lawyer with the Dinsey Law Firm. Prior to that, I served as Vermont's Deputy Attorney General under the TJ Donovan administration. Now I'm here today as Special Counsel for the Vermont Chamber of Commerce.
We appreciate the time that you're giving us today. I'd like to spend a little time talking sort of big picture where the Vermont business community is on this issue, and then Josh is going to dive into some of the details on this bill. And we've been working on this bill for a number of years, and this is the first year that we've had Josh working with us. And I think it's important to point out why we felt it was really important. We received a copy of the House version of this bill in late December, and it said there was 1,000 hours of stakeholder input. Last year, Vermont Chamber of Commerce, the Vermont Skiers Association, the Vermont Retail Grocers Association spent a lot of time trying to work through the challenges of this. And I can tell you 0 of those 1,000 hours were spent with any of our organizations. And it felt really clear at that point that Vermont businesses didn't only need an advocacy voice on this, but we needed a legal voice. And so we decided at that point to hire Josh so that he could provide that legal voice for the business community on this. And I want to be really clear starting out that we support comprehensive data privacy legislation and reform in Vermont. Ideally, this would be something that was handled at the federal level, right? Data, digital services don't operate within the confines of any state's physical boundaries. But we continue to see the federal government failing to act. So we understand that states need to step up. Since first commenting on data privacy in 2023, we've had 3 consistent requests with legislation. First, that the privacy law be regionally compatible. Second, that the Attorney General be supported as the sole enforcement officer with a specific private right of action removed. And that lastly, there be educational support for businesses to aid in compliance with a very complicated law. I think these 3 asks point to the business community saying, or not saying, let us self-regulate. We're ready to participate in this process. However, as policy proposals have moved further away from being compatibly regional with what is enacted in other states, and I think that's a really important differentiation of what is enacted versus what is proposed. We know thousands of bills get proposed in this building every year. We need to base our work on what is enacted. We have concerns about untested and confusing definitions, continued private rights of action being included, and moving in a way that will catch businesses getting it wrong to the benefit of litigators rather than helping them get it right to the benefit of consumers. The Information Technology and Innovation Foundation estimated that in the absence of Congress passing federal privacy legislation, a patchwork approach of state privacy laws would have substantial financial impacts, with U.S. small businesses bearing a $20 to $23 billion cost annually. Connecticut, New Hampshire, and Rhode Island have created a regional model of data privacy, which Bill S-93 is modeled after. Today, 18 business, nonprofit, and medical organizations, all based in Vermont, not in DC, sent out an op-ed expressing support for the approach taken to data privacy in S-93. And I would ask that you keep in mind the responsible Vermont-supported approach that S-93 offers. Businesses and nonprofits in Vermont are struggling. 3 years of double-digit healthcare premium increases, property tax increases, a payroll tax, and the economic uncertainty that tariffs and federal funding cuts are bringing. Any data privacy law will come with some level of compliance costs. But there's a way to do this that will streamline those costs while still offering comprehensive protection to consumers. We don't feel that the current version of S-71 does that, and we'd ask you to consider the changes that Josh is going to offer.
Thank you.
Thank you. And so at the end of the day, I think our position is, well, I know our position is, that S-93 really provides the better vehicle to provide meaningful consumer protections while creating a regulatory structure based upon a common understanding of definitions and requirements that have been adopted by our regional neighbors. And as a result, that strikes the right balance for both consumers and business here in the state of Vermont. And I'm going to try to highlight some of our top concerns with S-71, and when I can, contrast that with what's in the language of S-93 so that there's more clarity on that. So let's start with the application of S-71. And the application is broad because it requires businesses that collect, use, store, analyze, delete, or modify any data that is linked to an individual consumer to comport with about 65 pages of requirements. It's a big bill, a lot of technical oversight that is required. And most small businesses in Vermont don't have in-house IT capabilities.
And let me stop you there. Not all of the 65 pages are requirements, correct?
Well,
Most of them are definitions.
there's a lot of definitions,
Okay.
but those are
So
built into
it's a
the
long
requirement.
bill, but not all of it requirements.
It's a big bill. There are a lot of requirements.
That's definitely true.
And this application is going to apply by 2028 to those businesses that are either collecting, using, storing, analyzing, cleaning, or modifying data of 6,250 consumers in Vermont. So a lot of small businesses are going to be impacted by this bill that don't have access to in-house IT professionals and don't have specialized counsel, much less general counsel, to help them navigate these very technical requirements with potentially the threat of a private right of action. And so right sizing this is really important. And the advocates I know of this bill have said, well, you know, Connecticut's got 100,000. We should do this on a pro rata basis. I would assert to you all that that's not the right paradigm to look at this, but to look at what size businesses should be subject to that regulation. It's not just a strict pro rata ratio of population to population. The exemptions that are contained in S71, we believe, are too narrow as well. And in particular, S93 has an exemption for nonprofits that have recognition under the IRS rules for C3 charitable organizations, C4 social welfare organizations, trade associations, C6, and C12 cooperatives. We believe that strikes the right balance. Having that exemption, our nonprofits are under a lot of stress right now, in particular because of threats of impoundment of federal funds. And to add the cost of compliance with this to our nonprofit community, we think is not the right balance at this time. Many of the definitions, as we were discussing, Senator Plunkett, that are a part of this bill, we believe are unique, the part of the regional model, and often leave businesses with ambiguities about how to comport with the law. Let me start with the definition of consumer. S93 has an exemption for employees, which is not contained in S71. And that's important because many businesses do engage in data monitoring of their employees for legitimate productivity reasons. And if that exemption is not here, then that's going to create a whole new array of employee rights that could really wreak havoc on businesses who've got legitimate productivity concerns. Can an employee ask for a right for that information to be deleted or corrected or demand access to all that information? I don't think that's contemplated by S71, but that is part of what may occur without that exclusion. We heard testimony earlier about first-party advertising as being permitted under S71. My read of it is that it's not effectively because it doesn't allow for third parties to assist the first party that's collecting the data. There's no mechanism for that. The reality for most businesses, especially small ones, is they're going to contract with a marketing firm to help them with their advertising. So the law does not provide for that opportunity. And yes, S73 allows for targeted advertising, but as I'll discuss in a moment, and I'm sure you all are aware, there are core rights under S71 and S93. Those core rights still exist. If a consumer doesn't want targeted advertising, and sometimes they do, right? I don't know about you all, I alpine ski. I like the fact that sometimes I get ads about from ski equipment providers that I wasn't thinking about. There's a really good deal. It can help me stretch my skiing budget across the line. But if I don't want it, I can opt out. I can opt out of that on S93 as well. Publicly available information. I think there's general recognition that when you're dealing with publicly available information, that should be not regulated. It's in the ether. If public officials do something and it gets reported, or that's part of the public ether. I remember a day when they had what they were called white papers, where everyone's phone number was in a phone book that was part of the public ether. The problem with S71 is that there is an exclusion here that is really, really broad, that almost swallows the definition. Essentially says information collected and combined to create a consumer profile that is made available to a user at a publicly available website, or public information that's otherwise for sale. So what S71 is doing is effectively, it's not regulating content in that way, it's regulating the delivery of that information. And I think that could have negative impacts from general consumers who might be wanting to access the Google version of White Pages. But it also could affect all of you as well, to the extent that you are gaining access to voter information during election cycles. That's basically based upon public information. That availability may be shut down and may be your campaigns that are subject to these laws because you're tracking voter data in excess of 6,250 folks. Identified or identifiable individuals. So that definition also has ambiguities. And this is kind of a core aspect of this law that includes not only data that would allow you to reference a specific individual, but it also talks about specific or historic pattern of geological data as well as part of that. And this is one of our concerns by not utilizing a regionally adopted law. There is no definition for specific or historic patterns of geological data. There is a definition for precise geological data, but not specific or historical. So by Vermont trying to be an island with S71, we are not taking advantage of the good work that's been done in other states and the opportunities, again, to have a good balance between consumer protections and terms of art and use that have been tested already in other states. Sensitive data is another key definition, which addresses some of how we address consumer or data privacy. This definition of sensitive data in S71 goes beyond what I think are typically and recognized definitions of sensitive data, which are included in S93, like bio data, precise geological data, health data, things of that nature. It includes online activities over time and across websites, online applications that do not share common branding or data generated by profiling on such data. That's a real broad set of uses potentially that I think could have further complications as I talk about how sensitive data is handled under S71, and I'll get to that. So bear with me. If we can put a little pin in that, we'll get back to that. Scope of rights, section 2418. Both S71 and S93, I consider to have the 5 core rights, although S71 goes beyond that. The right to confirm what data is being utilized, the right to correct data, the right to access data, the right to opt out and to delete. But S71 also seeks to have businesses identify whether data is being used for AI. And the problem with that is there's no definition of AI in this bill. So where is that line between a sophisticated algorithm that my business might use to track client data or discovery in cases that I'm litigating versus what we might all think of as ChatGPT? And that line is not defined in this bill, again, creating ambiguity on potential enforcement with high stakes for many businesses here in the state of Vermont. And that is not a problem with S93. That doesn't have that undefined aspect. Duty of controllers and data minimization. Both bills address data minimization. Our concerns with S71 is that it interjects and uses terms of art that haven't been developed in other jurisdictions by minimization that is reasonably necessary and proportion. What does that term mean? I think people are getting comfortable with reasonable and necessary, but the addition of proportionate is not used in the other states. On top of that, under S71, that reasonable and necessary limitation has to be tied to a specific product or service requested by the consumer and communications that are not an advertisement by the controller to the consumer that is reasonably anticipated by the consumer within the context of the relationship between the controller and the consumer. It's a mouthful. So that, in our opinion, is very very narrow. And we think the better approach, which is found in S93, is make businesses identify what they're going to use your information for. Let's make that available to the consumers so that they understand it. And if they don't like those uses, they have the right to opt out, they have the right to delete, they have the right to correct, and so on. That we believe is a better standard than kind of these ambiguous terms of art that leaves businesses guessing about, well, what did the consumer really anticipate about the communication that they had with the company or the specific product or service that they're accessing. And yes, that could lead to targeted advertising. We would assert that that is something that consumers in some cases want, and they should have the option to that. The legislature shouldn't be in the business of saying categorically, Limits on the processing of sensitive data. Both bills do that. But there is a market distinction. Again, S71 is using languages that is not utilized in other statutes that leave businesses guessing what the standard is. It talks about strictly necessary. We think that's probably an overly broad term of art, as opposed to what is reasonable, or the generally accepted standards of minimization that we talked about, as well as that there's a categorical prohibition on sale or any data that is subject to valuable consideration. And we don't think that strikes the right balance. Yes, consumers should be protected and they should provide their express consent before this data is transferred for any consideration. That's what's in S93, but it shouldn't be categorically prohibited. It could really have adverse consequences on affinity organizations if you think about it. So it may be that I belong to a church group or a synagogue, and there are activities that are in common interest to other like-minded folks of a similar background in religion. And I want to be able to share that information so that I get notice about a rally that might be taking place in support of those ecumenical ideals that I find important. That can't happen. And that can happen under an array of affinity groups who might want the opportunity to share information, which would be considered sensitive because it could be about religion or ethnicity or race. And that should have consumer choice. Again, not the state saying absolutely no way. I'd like to talk a little bit about enforcement because this is one of the, I think, larger issues for my client. S93 imbues the Attorney General as the sole enforcement authority. That is categorically different than S71. But within that realm, there are still further differences. I think the Attorney General talked about some of them. We think that the Attorney General should be providing guidance to businesses on how to comply, that there should be in the initial phases of the implementation of this bill a cure period. And yes, if the Attorney General gave the hypothetical, if it is futile, then the Attorney General should have that discretion to enforce. But otherwise, should give the opportunity for businesses to cure, especially in the early phases of the bill. And that if a business comports with that guidance, so there's no games of gotcha, they can rely upon that and have a safe harbor and know that they are safe. But I want to talk about the private right of action as well. With all due respect to the Attorney General, I think she got it wrong because the statute's very clear, or the bill is very clear. There are liquidated damages that are available under S71 that are very similar to Illinois. It talks expressly about either $5,000 or actual damages, but it doesn't stop there. There's injunctive relief, which is something that's typically left to the Attorney General's office in their enforcement. That's usually not a remedy that happens in private lawsuits of consumer protection violations. Punitive damages on top of that liquidated damage for intentional violations. Vermont law does not typically recognize punitive damages from merely intentional conduct. Vermont Supreme Court, it'll be in my comments and I'll give you the citations, have said time and again that malice is the standard for punitive damages. And malice usually requires some showing of ill will towards another person, not because they made a bad business, albeit intentional decision.
Can you say that again? Malice versus what was the first one?
Intent. So under S71, punitive damages is available for intentional violations. But the history and tradition of Vermont law is you don't get punitive damages unless there's actual malice.
So intent with emotion.
Yeah, if you give me a second, I may actually have the site here. Malice may be shown by conduct manifesting personal ill will or carried out under circumstances evidencing insult or oppression, or even by showing reckless disregard for one's rights, which is a significantly higher legal standard. Every state.
I feel like arguing that because it seems like if you hurt someone, if you intend to hurt someone without malice, that's not a good thing either. But this is not the right time.
Yeah, it's a lawyer.
Yeah, I know.
I get-
But it's just,
Oh, those lawyers.
I know. Right.
Well,
I was
well,
told earlier that anytime you have more lawyers, they're against it. So
That's it. But I think the takeaway is that it's not consistent with
I understand
historic
what you're
norms.
yes.
And that's a concern for Vermont businesses. Every other state that's passed comprehensive data privacy legislation leaves enforcement to the Attorney General's office. Vermont would be unique and an island, and I don't believe the need is there. The Vermont Attorney General's office has the capability to create an effective deterrent, exercise good judgment on where to assess penalties and when not. And I would add that it's not unique to Vermont law either. The Data Security Breach Notice Act, which has been in place, I think, since 2010, leaves the Attorney General as the only enforcer of that law. That law, I think, is working. Yes, there's a lot of data breaches out there. That's just the reality of life in the modern age. But the Attorney General's office, I think, effectively creates a deterrent for bad acts and frankly makes money for the taxpayer here in the state of Vermont. If you look at the agency's budget and you look at the recoveries, a lot of those big dollar recoveries are coming from violations of that act. So I would assert to you all that Vermont consumers can be protected without the private right of action. It strikes the right balance for local businesses who will be impacted by this bill. And really, if we want to get something done that is good for consumers and it provides guidelines for businesses to know how to be good corporate citizens, S93 is the vehicle that we should be talking about and not S71 with a novel approach. Thank you. And happy to take.
Thank you. Yes, I would
questions.
like you to take questions.
can I jump?
Please.
Yeah, despite my jumping out of the gate, the hyperbole, I'm actually convinced a lot of what you said. So I guess my first question is, you're mentioning a lot of definitions that are in other states where laws have passed. Have they been challenged and interpreted by courts so that we have some case law?
There's very little. I think in New England in particular, those bills are coming online kind of as we speak.
Yeah.
I know that there is rulemaking in Colorado that may provide some guidance, but that law is not the same as the Connecticut model. It's
Yeah,
different.
I mean, if that's rulemaking.
And California's, I think, had rulemaking and certainly some litigation, but I don't think there's a lot of recorded decisions at this stage.
So completely different
And
law.
right, it's modeled under the European GDPR. So,
So in terms of the applicability, you're essentially saying business size versus number of consumers should be the way to go. In Connecticut, it's 100,000 for, I forget, 3 million, 4 million population.
Right.
Where do you think it got 100,000?
that's a
Do you have any clue?
I don't.
Yeah.
And in the interest of full disclosure, Rhode Island and New Hampshire have different numbers as well. I'm gonna get which one, not precisely, one's 35,000, the other's 25,000.
Okay. And we have 100,000.
In S 93 is 100,000, in S 71, it's 6,250.
That's right. That's what I was looking at S93 more this morning. Even though we don't have it for us. And just, and I may have missed this and you probably looked at it closer than I did. Can you walk me through the sale of personal data? Because I thought that it could be done by consent and
Under S93, sensitive data can be done by consent.
okay, you're talking about sensitive data.
Right.
Okay.
Sensitive data cannot be sold.
That's where I.
Yeah, that's the.
If they don't have any other questions. Thank you.
I'm sorry, did you? Okay. I have a couple of questions, just kind of background questions. So how many businesses are there in Vermont?
I don't know the exact number of
Just rough.
businesses. Probably 30,000, maybe fewer. I don't know that number.
Okay, and how many businesses under the Chamber of Commerce?
How many members do we have? Over 1,000. I don't have the specific number.
Do you have any idea like how many are you would call small businesses?
Of our members?
Yeah, no, it's just total. I'm just trying to get it.
90% of Vermont businesses have under 20 employees, but I would caution using the number of employees to indicate the use of data. We know restaurants that rely on things like Resi have a much higher risk. If you think about our nonprofits who are very much in this bill, the Spectrum Sleep Out is coming up. My son participates on it every year. They're collecting all of those folks who contribute and using that to continue the fundraising that they do to support homeless youth.
Right.
Nonprofits in general, they may not have a lot of employees, but they rely on their data to stay afloat, which is going to be especially important coming up. So I would just say, the number of employees is not necessarily a good indicator of whether or not folks are relying on data in order to sell. During COVID, we pushed our businesses. We said, especially to our retail establishments, you need to go online to survive, because everyone in this building is relying on the money that you bring in for us to protect our most vulnerable citizens. So we need you to go online. And they've gone online and they're using these tools.
Sure.
And we're okay with regulating these tools, but we need to do so in a way that isn't creating so much burden on them.
Oh, no, I agree with you. And I think small businesses are the ones who I see more protection for small businesses in some sort of regulation, wherever we end up, because they're they're in the same place as consumers in many cases where their information could.
I think on mid-size businesses and mid-size nonprofits are just as critical. I mean, these are the folks that can afford to pay a shakedown lawsuit, but can't afford to fight it. So when they get that letter, like we saw during the patent troll era, they get that letter saying, give us $10,000 or we're going to take you to court for violating this, or we're going to report you to the Attorney General. And they say, we didn't violate it. We think we're complying, but we can't fight this in court. We can't spend that money hiring an attorney, hiring an IT person to look through everything that we've done. We probably have to pay the $10,000.
Or their insurance company will pay it as well, demand that they pay it.
And this is not something that the idea that the private right of action hasn't been used in this way, I don't think accurately reflects what our business community has experienced whether it's from patent trolls or from folks who are trying to take advantage of ADA law. It is a real challenge and it is costing our businesses a lot of money
Currently?
currently.
Okay, so I'd like to hear more of those situations.
Yeah.
Do you have numbers on that?
Uh,
I have another question.
Yeah, we have examples of, from some of our members who have had to deal with, yeah.
Numbers, I want like actual figures that have been lost or some sort of data, not just like.
I don't know if there's any way to quantify, right? Because you get that letter saying, pay us
No,
$10,000.
I was asking if you guys had it. Not specifically. I just wanted to know if you had some sort of data that sort of backs up that thing, because I hear
I
about.
mean, I can send you
that's okay.
plenty of information about.
If we can get some, that would be
No,
great.
I've got data coming.
Because I hear about, you know, this is how lawyers
I've got data.
function, and so therefore the data privacy bill should be different.
Not all lawyers. We like plenty
I'm a
of
lawyer, so but I mean, it doesn't move me at all. It's like, you know, this is our judicial system, so it doesn't really tell me that this is something that's specific to this law in any way.
I don't think it is specific to this law. I think we've seen how this has been used in other laws.
So it's
And that's my
blanket all
concern.
over so consumers simply shouldn't be able to sue. That doesn't move me, but I'm just gonna, you know, like throw that out there. If there were data specifically in Vermont.
But I think that how many,
I've heard some anecdotes. So
if we have 10 consumers who have sued over the history.
Yeah.
We're creating an opportunity for those frivolous lawsuits because of 10 consumers who have sued over the history of this.
People can sue now for the same thing.
We'll have some,
I think-
we'll have some
The
people
difference-
that were sued under the private right of action. We have people I recommend.
That'd be great.
Private right of action. We have Vermonters sued by outside groups, exactly
Yeah.
like I asked the Attorney General, who said it doesn't happen. We will have examples.
You probably mean getting demand letters.
No, private right of action sued by private right of action. We'll have that.
Probably not.
And as far as businesses in Vermont, 83,000, small businesses, 76,787. Small business employees, 157,000, 60.2%
Yeah.
of all employees, small business employment percentage, so 60.2.
Thanks.
Yes.
Sorry, I got interrupted. You too.
No, and I guess, so just in terms of, you know, both of your organizations, you have data, you have data for your clients, you have data for your members. How do you protect that data?
Well, I have a duty of confidentiality, so, and
that extends to the data.
extends to the data.
Okay.
Here's my license.
Okay,
And so we have in-house IT capabilities.
and so a small firm, they would contract with somebody.
Yeah, I mean, and there have been instances of data breaches with law firms. It happens from time to time. And, it's something that keeps I think most of us in the profession up at night.
The breaches.
I work for the state.
We got sovereign.
I got answer that.
But yeah,
All right, but so you protect the data at a high level. It sounds like.
yes,
Okay,
yes.
so it can be done.
But at a significant cost. And not all businesses have the resources of either being a lawyer
Sure,
or having in-house counsel
right,
or that IT system.
okay,
And so how you right size it, and I think S71 doesn't right size it.
I understand.
And I think, again, pointing out that we are not opposed to data privacy, but what we're asking for is that there is regional compatibility. So how I treat my Vermont customers is how I treat my New Hampshire customers, which is how I treat my Connecticut customers, which is how I treat my Rhode Island customers. That it is easier and less expensive to say, I need to comply with these laws. And I can do so in a way that brings all these customers in regionally together. Because if we're all in agreement that this is a federal issue, that the federal government is failing to regulate, creating a regional model that says that we are going to set the model for how this should be regulated so that our businesses who aren't operating within and, you know, operating a nonprofit on the border of Vermont and New Hampshire, you have customers from both states. there's a challenge in trying to say, how do I ensure that the customers in Vermont have this regulation and the customers in every other state has a different regulation? There is a lot of cost associated with that.
Right.
So we're not saying no in any way. And we're not saying give us the weakest status privacy law out there. We're saying give us the consumer forward data privacy law that allows us to be regionally competitive. And keep compliance costs in a reasonable way.
I understand. Okay. Good.
And you support Ninety-Tree, right?
We strongly support S93. And I think, I think another piece that should be mentioned is last year, the governor vetoed H121 and his veto letter was clear. If you send me a bill that is regionally compatible without a private right of action, I will sign it. S93 offers a regionally compatible bill without a private right of action. We would like to see data privacy signed into law this year, and that seems to be the path to ensure that it happens.
Ideally, and obviously you brought my business into, so thank you. But our states, and I'm talking New England, can't agree on it. I mean, it just, I know that S93 comes a little closer, but it just in general, it is going to be difficult for our states to, because our municipalities within our states can't agree, within our state can't agree on things. So I just, that's just difficult. And yes, I do have a business that runs on both New Hampshire and I have difficulty with that on a number of things. Now I'm going to take off my business hat for a second, and put on what I'm doing right now. I want the most protection for the consumers of Vermont. And so I even though I'm a co-sponsor of S71, I just don't know it. So which one is the best for the consumers of Vermont, and that's what I'm looking for. In my role right now, I am there are the people of Vermont and the consumers of Vermont. That's what I'm trying to protect.
I think that is important, and I think it's worth asking for each section where one area deviates from the other. Are these changes adding to the protection of consumers? Are they offering new opportunities for litigation? And we are worried about the opportunity for the class, opening up Vermont for class action lawsuits, where Vermonters aren't the beneficiaries, where it's the attorneys of those filing class actions that are the beneficiaries. With giving the Attorney General the enforcement, we can tell those bad actors, we are coming for you, and the beneficiaries will be Vermonters.
And even though I'm not a lawyer, I know that you could.
I'm working on
We need
I know.
to
You
not-
can
We're together all day.
you can clerk.
I can
This could be working there for you.
Fair enough. But I know that anyone can sue for any reason for anything, no matter how frivolous. I mean, and that's also something as well, that have been on the other side of that. So, obviously have to take that into consideration.
Okay. Did you have something more, Senator Ingles?
I'm good.
Okay. Or, all right, are we good?
Thank
Okay.
you. And
Thank you so much.
just so we're clear, I appreciate this. I appreciate the balance and the contrast in both that for me, and I hope for my colleagues here, that gives us a basis of kind of compare and contrast the best option that we can go forward with. So I do appreciate that.
If I could just say, I deeply appreciate the deep dive into it.
Yeah.
This is what I've
Yeah.
want with every bill. I know we don't have time
Yeah.
for it, but I appreciate that.
And if we can be of a further resource to you all, let us know.
Yes, thank you. Appreciate it.
Be prepared to thought before. No, I want you to narrate audio.
Okay. So our next witness is Ariel Garcia, Chief Operating Officer of Check My Ads. So
Yes,
well,
hello. Everyone. Thank you.
thank you for being
Chair-
here.
Of course. Chair Harrison and members of the committee, thank you for the opportunity to testify today in support of S71. My name is Ariel Garcia. I'm Chief Operating Officer of Check My Ads Institute. We are an independent nonprofit digital advertising watchdog that advocates for a transparent and fair digital advertising market for advertisers and the public. I'm here today to share how this bill will benefit both Vermont residents and Vermont businesses. Prior to joining Check My Ads in 2024, I spent a decade in digital advertising, serving most recently as Chief Privacy Officer at Worldwide, which is a major global advertising agency. For years, I helped advertisers navigate the evolving regulatory environment as they look to strike the balance between privacy and targeted advertising. In fact, I resigned from my role precisely because of my realization that the only winners in the current state of the digital ad industry are big tech giants like Google and the data brokers and ad tech middlemen that thrive in their shadows. The $700 billion digital ad industry is the main business model of the internet, and today that business model is broken. Big tech firms like Google and Meta have built empires on unbridled extraction. They have amassed massive troves of data. They've cemented themselves on all corners of industry and society, unilaterally establishing norms that benefit their own businesses to the detriment of their users, of advertisers, and publishers alike. And yet, while these companies are household names, there are hundreds of other companies in the ad tech sector that have followed in their footsteps. Before the advent of modern digital advertising, advertisers would typically work with an ad agency to identify what publications or programs their target audiences are likely to consume. Today, however, most advertising online is transacted through an automated real-time auction. That's known as programmatic advertising. So over the past 2 decades, the main promise of programmatic was that it would help advertisers of all sizes more efficiently reach their target audiences while helping publishers monetize or sell more of their ad space. And so here's how that works. When a user visits a website, that triggers a bid request from the website to the supply side platform, or SSP. That bid request includes data about the user, like demographic information, browsing history, location, and the page being loaded. The SSP then sends it over to the demand side platform. And that automatically submits bids on behalf of advertisers for users that match their criteria. The highest bid will win, and the ad will serve to the user. And all of this real-time bidding happens automatically and near instantaneously. So advertisers today are typically reliant on a supply chain of various intermediaries, including these ad tech companies, the agencies that plan and execute campaigns for them, and data brokers. For every dollar a business spends on digital ads, each of these intermediaries gets a percentage revenue share, with most of those vendors paid on volume. That results in dysfunctional incentives because every company in the middle stands to gain by having more money pass through their pipes. In addition, in each transaction, these middlemen get access to personal data. This is how programmatic advertising resulted in constant tracking and widespread sale and leakage of consumer personal data. And while this process sounds efficient and powerful in theory, the reality is much different. Out of every dollar spent on programmatic advertising, only 36 cents makes it to the publisher. 29 cents of the ad dollar goes to ad tech middlemen. 35 cents is wasted on fraud, invalid traffic like bots, and low quality made for advertising websites. The average programmatic campaign saw a single advertiser's ad placed on 44,000 websites. All the while, even the biggest advertisers with the most leverage have limited ability to confirm where exactly their ads appeared. These figures from the Association of National Advertisers represent a conservative estimate. The costs do not reflect agency fees or ad verification tools. They don't include spend wasted on ads that, while not technically meeting industry definitions of fraud, don't adhere to the advertiser's criteria. So while research suggests that ad fraud accounts for $84 billion in global ad spend, placing it second only to the drug trade as a source of revenue for organized crime, that's just the tip of the iceberg as it comes to advertiser waste. For small businesses, this waste isn't just detrimental to their growth, but at times to their survival. So recently, we at Check My Ads launched an ad campaign where we emulated the experience of an average small business user. We set up a new Google Ads account, as thousands of other small businesses do. We were nudged into Google's AI-driven opaque product called Performance Max. This product is notorious for restricting advertiser transparency and control, and it has a history of placing ads on potentially illegal content while ignoring advertisers' targeting criteria. Sure enough, our ads were served on AI-generated spam websites and other low-quality sites that are more likely to attract bot clicks than real humans. Our ads ran on YouTube videos in other languages when we explicitly chose to target English content. With some of our ads landing on kids' videos, we have no idea who Google's algorithm targeted. But due to the opacity of the product, a small business can't determine what websites or YouTube channels increased sales or which audiences drove revenue for them. So while Google gets more money and more data, small businesses are merely the unwitting conduit. But this same phenomenon happens outside of Google's kingdom. The consumer data that's peddled by data brokers for ad targeting, while it's invasively collected, is also astoundingly ineffective for marketing. Research has shown that leading ad data brokers were only right about people's gender 42% of the time, worse than guessing at random. And this is what advertisers, including small businesses, are paying for. My own personal desktop research echoed these findings. One ad platform held over 500 audience segments to which I belonged. To their credit, giving that much information is very uncommon in the absence of universal legal requirements. But these audiences were highly inaccurate, often contradictory, and sometimes sensitive. According to the data, I am both high income and below the poverty level. I'm listed as both a middle-aged suburban homeowner without kids, as well as a mother of two. I am neither. I'm, according to my profile, a defense contractor, but I also work in food service and agriculture. I love and hate my job. I was identified as likely suffering from heart disease, speaking Spanish, and celebrating Ramadan. None of these things are true. And while the industry has finally started to acknowledge these data quality realities out loud, that insight is far less accessible to small businesses. Yet, right or wrong, this data can be used within and beyond advertising in ways that cause real harm. The chief privacy officer of Acxiom, which is one of the world's largest data brokers, has admitted that their consumer data used by advertisers around the world is comprised of little more than, and I quote, informed guesses. He said he hopes that if they guess wrong, it doesn't have any negative consequences for denial of benefits or credit. But credit reference agencies have purchased and used Acxiom's data to determine creditworthiness. Another data broker, Epsilon, now also owned by an ad giant, has sold data to perpetrators of elder fraud. Its parent company, Publicis, recently announced its acquisition of another data broker, which it claims will give it deep insight into 91% of the world's population. It's a scary thought, given that this is 2 years after the same company's health unit entered into a $350 million settlement for its role in the opioid crisis. As Attorney General Clark may recall, among the allegations, Publicis Health was accused of using doctor-patient recording data to glean insights on how to more effectively push opioids on pain sufferers in higher and higher doses. Meanwhile, Publicis's data broker unit Epsilon, as recently as 2021, continued to sell data pertaining to pain sufferers and may still do so to this day. So without privacy laws like S71 that codify transparency and choice, that include principles of data minimization and restrict use of sensitive data, these data-enabled harms would continue unchecked. All of this so that data brokers and ad tech companies can sell data that has less than a 50% chance of being accurate to unsuspecting small business advertisers. This is the alleged pinnacle of efficiency that props up the industry's complete disregard for consumer privacy. To be clear, this false promise of precision targeting is not what helps small businesses grow, nor is it what helps publishers sell ad space for a fair price. It is what the tangled web of middlemen rely upon to justify their own high margins and to sell ad space that otherwise would not sell. It is the illusion that underpins big tech companies' untouchable supremacy. So to close, this bill that would protect the privacy of Vermont residents is not at odds with relevant, effective advertising. This bill would not end all targeted advertising. What it would do is reduce the supply of low-quality data at the core of the broken market that is ad tech. Ultimately, it would start to create the conditions for more relevant advertising that benefits Vermont's businesses while restricting the harmful practices that undermine the safety, liberty, and security of its citizens. Thank you once again for the opportunity to speak today.
Thank you. It's very helpful. Do you have any questions?
I don't have.
So will you provide written testimony, please?
Yes, I will.
You had a lot of information in there, so we can go back and read it.
Absolutely.
Sure. Thank you. Anybody? Okay. Okay, so thank you. So we will move to our next witness, who is Melanie Ensign, founder and CEO of Discernible Inc. Thank you for being here.
Thank you so much for having me.
So you can just let us know what Discernible Inc. does and a little bit of your background, and let us receive your time.
Absolutely. And thanks so much for the invitation and for folks taking the time to have these kinds of conversations. I think to the senator's earlier point, being able to dive deep into these types of bills, I think is really important and something that has been missing in a lot of legislatures across the country. So I applaud you for going this deep into the details, because it really does make a difference for every individual consumer. So a little bit of background about myself. I have spent the last 20 years in privacy and cybersecurity, including working on the front lines of major breaches such as the NSA revelations, Cambridge Analytica, and a whole host of missteps that defined the early days of Uber out in San Francisco. I myself am a small business owner. I founded Discernible 5 years ago, and we are focused on helping security and privacy professionals inside these companies gain more influence over the decisions that the businesses are making. And I have seen firsthand everything from data-hungry executives to competitors hacking each other for intellectual property and privacy failures. I recall for years and years as a member of the corporate communications team at Facebook, we would tell people that the phone numbers that people were providing for their two-factor authentication for their account security was only going to be used for that purpose. And behind the back of the privacy team and the security team, the advertising team took a hold of that database and started using it for targeted advertising purposes. So I think because of what I saw during my 2 decades in telecom and tech, I decided that when I started my own company, I was going to do things very differently and intentionally. And truth be told, I'm not really here to advocate against taking away everybody's sugar, but I do think we should get rid of the kind that is laced with rat poison. I also don't have in-house IT support or legal counsel. I outsource both of those things to trusted contractors. And as a result, I'm very picky about which marketing firms and contractors I will work with, because I know that many of them are drinking the Kool-Aid of tech and ad platforms, which actually increases the risks for my business. Because simply meeting a bare legal floor requirement doesn't build trust with my customers. I believe it's bad marketing and it's poor brand management. In my written statement, I won't go through all the details now unless there are questions about it, but in my written statement, I have provided examples of some of the marketing and promotional techniques and tactics that my business does use in order to avoid what we consider to be invasive and surveillance technologies. Now, I do want to note that as a small business owner, my greatest privacy challenge is that I can't find privacy respecting solutions and vendors despite my willingness to pay for them. As an example, we use a very popular template-based website design and hosting solution that lots and lots of small businesses use. Even though I have gone through and turned off all of the trackers for my website, I cannot get them to remove the metapixel code from the source code in the website. And so it is dormant code sitting on my website that's not collecting data, but is creating a security vulnerability for my business. I also want to note, and there's more details on these things in my written statement, but if you're not already familiar with the websites builtwith.com and Blacklight, which is from it was built by the investigative journalism organization called The Markup. These are free diagnostic tools that I use all the time, and other small business owners can use them as well. It helps me discover the hidden trackers that are living on my website and the website and platforms of the service providers that I use. And so the fact that even as a small business owner, I have the resources to pay for more privacy controls, there just aren't that many vendors who are willing to give them to me. And I think that that is a huge part of some of the conversation that we've heard today, where, we're talking a lot about the data that small businesses know they're collecting. But there's a lot of data that we don't know that we're collecting and sharing and sending to all of these other service providers, because they're hidden from us as well as the small business owners. In fact, until Blue Sky and Mastodon recently emerged, my business had to choose between digital isolation or surveillance platforms. To this day, we have never had an account on a Meta platform, and I'm really, really proud of that, and I don't regret it. The current situation that we're in as small business owners actually forces us to issue privacy policies that feel more like a statement about use our service at your own risk, rather than a conversation about healthy boundaries with our customers. I just recently went through this process because we have launched our first subscription service this year. And previously, we did not have a business that required a privacy policy, and now we do. And it was the worst experience as a small business owner to write this policy that, number one, I knew could only be understood by lawyers who are not my customers. And I hated the fact that because of the privacy decisions of the vendors that I'm forced to work with, I'm telling my customers, I'm trying to be as transparent as possible. What I'm telling them is, there just aren't enough options in the market for me to give you the kind of privacy protections that I think you deserve. And that is a really difficult position for us to be in as small business owners. There aren't the tools for us. I also want to note, having spent my previous career in the big tech space, that I think there's this false narrative that privacy legislation is bad for small business. It's not that there aren't implications. It's not that there aren't consequences. But we could have laws that are offering us financial and technical support in doing the right thing, rather than using small businesses as human shields in order to protect big tech's surveillance-based business models. They've not only convinced a lot of legislatures around the country that invasive tracking is essential for success, but they've convinced a lot of small businesses of this as well. And that's one of the reasons why in my written statement, I did include some alternative practices that my business uses, because we're thriving without these things. I've worked inside the tech platforms who run advertising businesses, and I'm now a small business owner. And I don't believe that these invasive technologies are a requirement for success. My own experience just does not prove that thesis. I also want to note that as a small business owner and an expert in security and privacy, data is a huge liability for us. Collecting excessive data creates security risks that a lot of small businesses truly can't manage. We have this concept in the cybersecurity industry called the security poverty line, which truthfully is where most businesses are because we lack the resources to properly protect really sensitive data. And in fact, there's a misunderstanding among a lot of small business owners that we're not an attractive enough target for a determined adversary to try to steal or attack our infrastructure in order to get that data. But according to the Verizon Data Breach Investigations Report, I know that's a very long name, and there is a link to it in the written statement. But this is considered an authoritative source of information on an annual basis for cybersecurity professionals on kind of the state of different kinds of attacks, because it's based on real incidents that have happened to thousands of companies around the world. And in 2019, they specifically called out the fact that small businesses represent 43% of all data breaches. We are both a direct target because adversaries know that we don't have the same kind of protections as the big tech companies, but we're also an entry point into those larger companies because we are part of their supply chain. So if you think about some of the biggest cyber attacks in recent history, starting with Target and then SolarWinds and all the ransomware attacks on healthcare facilities, these are coming from smaller companies within the supply chain of these organizations. So it's really irresponsible to suggest that because we are a small business, we are somehow less responsible for protecting the data that we are knowingly collecting. And that's another reason why I think it's important that we note that there's data we may not be aware that we're collecting, right? Using those free tools to identify what's actually happening in our platforms is really important. Now, there's a couple of benefits of S71 that I do just want to note as a small business owner. And this section is very brief because I do not live in Vermont. And I trust that Vermonters know what is best for them. So I am not going to play tit for tat on every single piece of the proposed bill. But I am here to provide you with another side of the story that you have been fed by industry. And so I want to start with the things that I think are really good in this bill, which is the phased implementation, right? It does acknowledge the reality that small businesses will need reasonable timelines and a runway to get up to speed on some of these things. It also attempts to level the playing field to ensure that all businesses can operate with similar privacy standards. It also aligns with a lot of best practices. Data minimization and purpose limitation aren't just good from a business perspective, but I don't have to pay to store or secure data that I don't have in the first place, right? Either because I didn't collect it or because I have really strict and short retention policies. I also appreciate the fact that S71 offers Vermont businesses a way to differentiate on privacy as a brand value. And I think that's something that's really important as more and more consumers get smart on the fact that this isn't just if I have something to hide kind of a situation. There's a lot of manipulative and abusive behavior that can happen in the wrong hands. Just because somebody has information about you that you didn't intend to share with them, perhaps you don't even know they have that data. My one piece of recommendation that I did want to know on this particular bill is perhaps in future iterations, thinking about regulating based on data sensitivity rather than just company size or volume of data. if we think about the way that we regulate safety in the physical world, we don't give people different rules for hazardous materials based on the size of their organization. If you have material that can cause harm or impact public safety, there's one set of rules that applies to everybody. And the last thing that I want to note is that if there is a way to improve the legislation to help address the market failure in the privacy respecting tools that we could use as small business owners, that would also go a long way in helping the small businesses in Vermont do this in a cost-effective, seamless way. So thank you so much for your time. I'm open for any questions.
Thank you very much. The market failure of privacy tools is really interesting to me because the tracking that you talked about, I used to have that tracking that was part of my browser and went away. I want to find it again, and probably that was intentional. I'm not sure, but yeah, it's really hard to find those, and it's interesting to hear about local businesses being such a big part, and they receive data breaches. Is what I'm hearing. And they don't have to pay to store the data. That's interesting too. Can you talk a little bit about that? Because we haven't talked at all really about data centers. But those are just just side note, last year we heard from a middle school boy that he took 100 pictures of himself every day. So photographs have a lot of data in them. So, and we don't have as many middle school boys and girls as we want, but that's so much data that someone is paying to store. Can you?
Sure. So from a small business perspective, it's actually more cost effective for us to store this in the cloud than to have our own server, which creates additional issues, right? In terms of cost, it's usually based on how much data are you storing, right? So whether you're using AWS or Google Cloud or Azure or something else, you're paying based on how much real estate you're taking up in their data server, right? It also opens us up to potential new risks in the sense that this is data that has been shared with me that I'm now storing in somebody else's infrastructure, right? So that's the type of disclosure that has to be in our privacy policy to let folks know it's not sitting in my office, the data, right? It's in our cloud provider environment. I chose to make that decision because as much as I abhor some of the privacy practices of these large companies, they have infinitely more resources than I do when it comes to cybersecurity. And so the likelihood for the data to be stolen from those companies compared to if I was hosting my own server and running my own cybersecurity defenses, this is actually the way that reduces the risk for my customers. But because I know that that data is not sitting physically with me, I'm very protective of it. And I don't want anything that I don't have to have. I have fought with e-commerce platforms to make sure they're not sending me emails about every single order that is purchased. That includes everybody's personal information. I don't need that in my inbox. Don't send that to me. And these are the types of things where as a small business, I don't have the clout. I don't have the kind of lobbying power to go tell those companies that they need to offer other features. I'm willing to pay for this. Going through and creating my privacy policy was a really demoralizing exercise because I was going through and telling my customers as honestly as I could, this is why I chose these platforms. They're not 100% in the areas where I think they should be, but you deserve to know what's happening, right? And the fact that this is my website, I've paid for the domain, I pay to host the website, I pay for the design, and I can't access the source code as the owner, that is absolutely insane to me that I can't get a metapixel removed, even though right now the code is dormant and just creating a potential vulnerability.
Right. All right. Thank you. I have one more. Does anybody else? Just one more question. Do you know of any university or some sort of nonprofit? Because I appreciate what you said about having software available for folks to protect their information. Do you know of anyone who's trying to develop that at scale?
Not necessarily. I mean, the two tools that I mentioned are less about the protection side. I mean, it's not a security protection, but even just knowing what's happening on your website, I bet the majority of small business owners have never looked at the source code of their website. And why would they? That's not what they're passionate about, right? They're passionate about selling the thing that they're selling. And just being aware of this is what your website is doing, this is what your tools are doing. It's so easy to just go in and turn off as much of that functionality as you possibly can. And then, but that gets you to a certain point, right? And so I'm now, yelling at chief security officers at all these vendors saying, where is your influence in this organization to enable me to remove a significant security vulnerability from my website that I'm paying for? And so I think that is a piece of the market that current legislation has just kind of neglected to take into consideration, that it's not just what the big companies are doing. It's the fact that the big companies are making it hard for the small companies to exercise control over the data that we are collecting.
All right, great. That is really helpful. Thank you. Anybody else? Okay, thanks a lot. And you said you either have or will provide written testimony, I believe.
I have.
Oh,
Yes,
good.
you have it.
Thank you. Okay, thank you. Okay, so that is all I have on our agenda. Kayla, there's nobody else, right?
No, but Rick stopped by. He's available till 3:30.
Oh, okay. That'd be great. If he has any, I don't know if he's had a chance to look at what we've done, but that'd be helpful.
Okay. Do you want to go?
You know what? Let's take a let's be bold.